Good evening, Your Honors, and may it please the Court. My name is Ashley Jovic, and I represent the United States federal government, along with my co-counsel. Tonight, we will be addressing the constitutionality of the Voting Rights Act and the proper judicial standard of review for legislation governed by the 15th Amendment. Shelby County contends that Section 4B and Section 5 of the Act, as extended by Congress in 2006, are outdated and no longer constitutionally justifiable. On the contrary, the evidence of racially discriminatory practices in the covered jurisdictions is still sufficient to show a continuing need for the coverage and preclearance provisions. The Voting Rights Act still actively protects minority voters' ability to fully participate in our country's political process. In addition, Shelby County's suggested standard for review of this case is not supported by the courts or the Constitution. Looking to precedent, the Congress is entitled to significant deference. The Act's provisions are easily justified when viewed under the correct rational basis standard. Before we talk about the standard of review, let's start from the beginning. Why did this country even need the Voting Rights Act in the first place? When the 15th Amendment came out in 1870, there were people who said right away, this will be easy to evade. And it was. As President Johnson explained, in many places in this country, men and women are kept from voting simply because they are Black, and every device of which human ingenuity is capable has been used to deny their rights. Historically, in the jurisdictions subject to preclearance to the Voting Rights Act of 1965, discrimination was both overt and violent. Look no further than one of the tragic catalysts for the enactment of the Voting Rights Act, which occurred only an hour drive from Shelby County. This nation should never forget the violence and terror of the 1965 Bloody Sunday events in Selma, Alabama. On that terrible night, with no provocation, peaceful protesters marching for Black voting rights were confronted by state police. The marchers were savagely beaten with clubs, whips, and barbed wire. Television cameras captured the entire assault, and the world witnessed the southern state's disturbing brutality against African Americans. The events in Selma galvanized public opinion and mobilized Congress to pass the Voting Rights Act. After the effects of Bloody Sunday rippled through the chambers of Congress, and after nearly 100 years of many southern states' blatant disregard of the 15th Amendment, Congress then employed its considerable power to begin the work of eradicating discrimination of the voting process. The Voting Rights Act made significant impact in transforming the culture of racist voter suppression that characterized parts of this country for over a century. The Voting Rights Act is universally recognized as the country's most successful piece of civil rights legislation. The Act enshrined our most fundamental values of guaranteeing to all of our citizens the right to vote. The provisions of the Act are considered by Congress to be an efficient and effective mechanism for deterring and redressing the many forms of discrimination that continue to taint our democratic process. Section 4B of the Act contains a formula to define which states and counties are covered. The original formula looked to each jurisdiction's history of voting discrimination. During each of Congress's many reauthorizations of the Act, they looked to evidence of each jurisdiction's historical and recent voting discrimination. Under the Act, these covered locations were required to obtain DOJ or federal court approval before implementing any changes to their voting laws. These jurisdictions must demonstrate their proposed voting changes do not have any racially discriminatory intent or effect. The Section 5 preclearance process serves as our democracy's voting discrimination checkpoint. For nearly 50 years, this preclearance governance has stopped thousands of discriminatory voting changes before they happened. While the Act was a great achievement, voting discrimination is not a thing of the past. Although the Act resulted in great strides forward from Jim Crow-era disenfranchisement, jurisdictions today are still attempting to restrict the ability of minority voters to exercise their right to vote. Modern discrimination, although perhaps more subtle, is still devastating to the voting rights of minorities. Lawmakers in the covered states continue to discriminate against minority voters by various means, including restrictions on early voting and voter registration drives, onerous voter identification requirements, and discriminatory redistricting plans. Indeed, much effort and imagination continues to be invested in preventing Black people from voting. The Act, including its coverage and preclearance provisions, remains necessary to protect minority voters. The Supreme Court has upheld the constitutionality of the Voting Rights Act on at least 4 separate occasions. The 2006 reauthorization of the Act was a signal legislative event. The Senate voted for the reauthorization 98-0. The 98 votes included every senator from covered states. The Act was described by then chair of the House Judiciary Committee as one of the most extensive considerations of any piece of legislation that the United States Congress had dealt with in the 27 years he had served in the body. Now let's look to the proper standard of review for this type of legislation. Congress has broad power to choose how to remedy state violations of the 15th Amendment. Appropriate legislation is the language the framers used to define the scope of Congress's authority. The wording reflects a decision to give Congress wide discretion to enact whatever measures it deems appropriate. Indeed, the framers granted Congress the sweeping authority of Article I's necessary and proper powers. Kozenbach held that the preclearance and coverage provisions of the Voting Rights Act, the very same provisions Shelby County contests here, were appropriate legislation within Congress's 15th Amendment enforcement power. The court said, Congress may use any rational means to effectuate the constitutional prohibition on racial discrimination in voting, and it is not for us to review the congressional resolution of the need for the chosen remedy. It is enough that we are able to perceive a basis upon which the Congress might resolve the conflict as it did. The Katzenbach court described the pre-clearance checkpoint as the heart of the Voting Rights Act, and to be a valid means for carrying out the commands of the 15th Amendment. The court acknowledged that the section was an uncommon exercise of congressional power, but found it was justified by the insidious and pervasive evil which had been perpetrated in certain parts of our country through unremitting and ingenious defiance of the Constitution. In addition to using this rational means standard, which is essentially the highly differential rational basis test, the Katzenbach court analyzed the history of the 15th Amendment and affirmed that the framers indicated that Congress was to be chiefly responsible for implementing the rights created. The Supreme...
So, does this mean basically we should just, rubber stamp whatever Congress does in this area? It sounds to me like you're saying we should just go along with whatever Congress says. That's your view?
Not entirely. The standard is highly deferential, so it is assumed that what they did was correct, but it is still analyzed that there was a rational decision that they made. Here, the court's role then is not to substitute the judgment for that of Congress. Instead, the court must determine with deference if Congress made a rational judgment that the evidence it reviewed was sufficient to justify reauthorizing the Act's provisions. The Supreme Court later applied Katzenbach's rational means standard again in the City of Rome versus the U.S., where the City of Rome attempted to claim that the pre-clearance requirements were unconstitutional. Rome's claim failed under the rational means standard, and the Voting Rights Act was once again upheld. I will now hand off to my co-counsel, who will explain how this highly deferential rational means standard provides that in this case, Congress's judgment should be upheld and sections 4B and 5 of the Voting Rights Act remain constitutionally sound.